What happens if I die without a will? And if you've listened to this podcast, you've heard about what happens without a will. And so that means that we're going through an intestate probate process. So if you die without a will, which means you die intestate, when you die with a will, you die testate, if that helps any. Your estate, including your house, is divided according to what the state law says for intestate succession. So if you die without a will, in Washington, if you're married, your spouse typically gets all of your stuff, right? If you're not married, typically your kids would get it, right? If you have kids. If you are not married and don't have kids, then typically your broader family tree gets it. Maybe your parents, your siblings, nieces and nephews, sort of down the line.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning can often be a confusing and complicated topic, but my goal with this podcast is to make it accessible and understandable to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic. Today's topic is, what happens to my house when I die? Because we've all had this question come up before. Knowing the answer allows us to plan accordingly and effectively. So on today's show, we're talking about what happens to my house when I die. So let's get to it. Home sweet home. One of the most common things that Americans dream about is finally getting their own house, your own piece of dirt. The American dream. We always think about what we want our house to have. 2-car garage, a nice open front porch, maybe with a rocking chair on it. I don't know. A main suite with a bath attached and a great kitchen, right? Everybody wants a great kitchen. But do you ever wonder what happens to your house when you die? Who pays the mortgage? Does it have to be sold? Can my kids keep it in the family? Will they want to? So on today's episode, we're talking about just that. What does happen to your house when you die? And I broke this episode down into some sub-questions, that we'll go over that answer different scenarios, okay? So we'll start with, what happens to my mortgage, right? And so a mortgage is basically the loan that you have on your house, right? If you have a house or getting a house, you know that you have to have a mortgage. Typically, most people have a mortgage on their house. But when you die, the mortgage doesn't go away, right? It doesn't disappear when the homeowner dies. The debt is still owed to the lender. And the reason why is because the debt is secured with, in Washington, we use a deed of trust to secure that mortgage on your house. So the house is collateral and security for the bank, that if something happens to you and you can't pay the mortgage, they can come get that house, right? And so the responsibility to pay for that mortgage passes to the estate and ultimately to the beneficiaries who inherit that property. And the consequence of not paying the mortgage is that they can come and foreclose, right? The house will be foreclosed on. In some cases, and it's not as easy as it used to be in the old days, which is before my time, old days, but it's often possible to assume the mortgage for a beneficiary or continue to pay it. Typically, mortgage companies don't, as long as you're paying the mortgage, they don't really care who is paying it. But in other cases, you can assume the mortgage, but especially now where we have a pretty high interest rate environment where if there's a mortgage on a house that was financed a few years ago, the mortgage is probably a lot lower than you could get now. So assuming the mortgage might be a really beneficial thing to do. And so it's possible that you can assume the mortgage, which means you take it over and you're now responsible for paying it and you're now liable if it doesn't get paid. And so that's a lender by lender, case by case kind of situation. So it's not a given. And then a lot of the time, if your parents are elderly and they don't have a lot of savings and they needed a little extra money, their house was already paid off, they may have opened something called a reverse mortgage. And a reverse mortgage is the opposite of a regular mortgage, where I've got a paid off house, but I want to use it as sort of my piggy bank to cover some expenses because I need a little bit of extra money. And so a reverse mortgage is when the mortgage company lets you take money out of the house from the equity of the house to use for whatever you want it for, right? And they usually cap it at a certain amount and a certain loan to value rate. And so percentage. And so this reverse mortgage, the difference between a regular mortgage and a reverse mortgage, though, is during the lifetime of the mortgage holder, the borrower, they don't have to pay the mortgage payments. And so what happens is that reverse mortgage generates interest, and that interest gets added to the principal balance. And when someone dies, they typically have to get that thing paid off. And so that means they have to either sell the house or they have to refinance it. There's no assuming the reverse mortgage because typically you have to be a senior to get one. There's age requirements. And so you can't typically assume it, and you're going to have to pay it. And typically they give you some leeway. They don't typically get it like, okay, they died, they're going to go get it the next month or whatever. They give you several months to get that coordinated. But that's another thing to think about, because maybe, mom and dad's house was paid off, and you may find that they got a reverse mortgage because they weren't making a payment that you noticed, but there is a lien for whatever the amount of that reverse mortgage was. So if the sale doesn't cover the loan balance, then the estate would be on the hook, potentially. But most of these reverse mortgages are non-recourse loans, so they don't typically come after the estate. And they definitely wouldn't come after the beneficiaries individually. So they usually have to sell the house or refinance out of it in those kinds of situations. So we know what happens when we have a mortgage. What happens if I die without a will? And if you've listened to this podcast, you've heard about what happens without a will. And so that means that we're going through an intestate probate process. So if you die without a will, which means you die intestate, when you die with a will, you die testate, if that helps any. Your estate, including your house, is divided according to what the state law says for intestate succession. So if you die without a will in Washington, if you're married, your spouse typically gets all of your stuff, right? If you're not married, typically your kids would get it, right? If you have kids. If you are not married and don't have kids, then typically your broader family tree gets it. Maybe your parents, your siblings, nieces and nephews, sort of down the line. And so that's kind of what happens in an intestate succession without a will. And so if a single person dies with no kids, their property goes to their parents or siblings down the line, right? We'll get into what the process for that is in a minute. It's probate. I'll give it to you. Okay. What happens if I die with a will? Okay. And so with a will, if you die with a will, if you die testate, that allows you to dictate and provide for who gets your house, right? And so if you want it to go to your spouse, or if you want it to go to your kids or a certain kid or your best friend or whatever, your will can designate that, right? Or your unmarried partner, your will would designate that. If you don't have a will and you're not married, then there's problems if you want it to go to your unmarried partner. So the will allows you to clearly state your wishes regarding who should inherit your stuff. You also name an executor to administer that will. That's the person in charge. And to ensure that the things in your will are fulfilled, right? And the instructions are followed. And the process, though, with a will and without a will is the same, okay? You have to go through probate. And probate, real briefly, is a court proceeding where we go to court and an executor petitions the court, whether there's a will or no will, to be appointed to administer an estate for somebody. And the reason is this. When you die, you can't sign your name anymore, right? And probate is all about clearing title to assets. And so if you have a house with title, or if you have an account with a title, right, with your name on it, someone has to be appointed by the court to administer that asset, which means they can sell it or they distribute it according to your will or according to the state law, right? But they have to get court authority to do it. They don't get it from anybody else, okay, in a will or no will situation. And so a will requires certain steps to make it valid. It has to be formally witnessed and executed, and that varies from state to state, but we won't get into the formalities of that. The negative of dying with a will or without a will is this probate process, though, right? We don't want to have to do it, ideally. We don't want to have to validate the will. We don't have to get appointed by an executor. We don't want to have to tell the court about what we're doing. We don't want it to be a public record, right? We don't want to have to pay another lawyer a bunch of fees to do probate. We don't want to wait a bunch of months, usually 6 to 12 months typically, to get a probate done, to administer an estate. So that's the negative, okay? The probate process for both with a will or without a will. Third thing to talk about. What happens if I die with a trust to my house? Okay. Trusts are an effective way to manage and transfer your asset. In a revocable trust, which is the typical kind of trust that people make during their lifetime, you retain control over your assets during your lifetime. They're amendable. They're easy to change. Put assets in, take assets out. And a trust, the benefit of the trust is that it avoids having to go through probate. And the reason why is this. With a trust is a quasi-entity, right? It's basically something that's an entity that holds title to property, okay? And so if the house is titled in the name of the trust and you pass away, the trust says who's the next person that's going to be in charge. So a trust has three parties, basically. Someone that sets it up called a grantor, someone that manages it called a trustee, and someone that benefits from it called a beneficiary. During your lifetime, typically you're all three of those things. And so in this situation, if you're the trustee during your lifetime and you die, the trust says, appoint so-and-so to be the successor trustee when I'm not around. And the trust also says, when there's trustees involved, they can do certain things, right? They can buy and sell assets. They can administer other assets. They can distribute according to the terms of the trust. You know, they can hire realtors and all those kinds of things, right? They can talk to the mortgage bank, all these things. And so rather than having to go to court to get appointed as an executor, the trust has authority granting provisions to say, whoever follows me on this deal can act, okay? And so you don't have to go through probate. And the trustee can distribute the house according to the terms of the trust, whether that means to sell it or distribute to a certain beneficiary or whatever, right? And so the trust is a much more streamlined way to die with a house because you typically don't have to go through probate. So, okay, are there any other things that I can do to transfer my house without probate? And the answer to that question is yes. The first thing we'll talk about is joint ownership with right of survivorship. Joint tenancy with right of survivorship is what we call it in Washington. That means that two or more people own the house, right? There's two or more people on title, and they own it as joint tenants with right of survivorship. What that means is it's joint. We know what that means. Right of survivorship means when one of the joint tenants dies, the property immediately vests, basically. It stays with the other joint tenants. So by operation of law, the deceased joint tenant's name is taken off the house and it stays with the other surviving joint tenant. And so it automatically passes. There's no probate. This is sometimes used for married couples. It's not very commonly used, though. And you can also do this with your kids. I don't recommend it. So you can say, if your husband and wife own the house as joint tenants with right of survivorship, when a husband dies, it immediately goes to the surviving spouse. That deceased spouse's name comes off, okay? The negative thing is this, though. If you have it with your spouse, it's not as big of a deal. Like, it's totally okay to have a house joint tenant with right of survivorship with your house. I don't recommend it for when you're trying to give it to your kids, though, or anybody else, really, that's not your spouse, or a partner that you're non-married partner, we'll say. And so that has a stake in the thing. And so the reason why it's a negative potentially is because if you have a joint tenant on there and it's just for, well, I don't want Johnny to have to go through probate when I die, but I don't want to buy a trust. I don't want to pay for a trust or anything else. I just want to do a joint tenancy with right of survivorship, and I'm going to put them on title now. And when I die, it'll go directly to Johnny. And so the problem with that is what happens if Johnny gets someone coming after him for money, right? Someone sues him because he was in a bad car accident and he injured somebody. Or what if Johnny gets divorced? What if Johnny's terrible with money and has tons and tons of debt and his creditor starts suing him? What if he has to file bankruptcy because of this, right? And so if he has to do any of those things, guess what's on the hook? Your house. And so you don't want to name your kid or anybody that's not tied to this house with a financial interest as a joint tenant with right of survivorship because it's just a problem. waiting to happen. And the other issue is if you die and Johnny's in a real bad situation, Johnny was perfect during his lifetime, but he, right before you die or right after, something crazy happens, right? One of those things. He gets divorced, or he gets in a bad accident and owes tons of money, or he goes and has a medical issue and doesn't have insurance, right? And he owes a ton of money. Joint tenancy doesn't allow him to postpone that distribution at all. It doesn't allow for any changes or amendments to anything after the fact. And so that house is gone in that situation, right? That house is going to be taken by the divorce. It's going to be taken by creditors. It's going to be taken by the hospital bills, right? In a divorce situation, I'll give this one caveat. Typically, inherited property is separate property, so it might not be part of the divorce, but there's a question as to whether some of that might have to go to your divorced spouse. And so, why risk it? Okay. The second thing you can do to avoid probate without doing a trust is something called a transfer on death deed. And a transfer on death deed allows you to name a beneficiary who will inherit your house when you die without going through probate. Okay. And so you're really not putting their name on the house. You're really saying, I'm giving this house to my son, Johnny. In these examples, Johnny's our son. And we're giving him the house when I die. So when I die, transfer this house upon my death to Johnny. Okay, that's what the deed essentially says. And so you retain full ownership. You don't have to worry about any of those joint tenancy issues with Johnny's divorce and his creditor issues and all that stuff, because you don't want to have to deal with that. So the advantage is the process is simple. You don't go through the probate. It's a little bit cheaper than a will or a trust. You should still have a will if you have a transfer on death deed, though. Don't, because it only deals with your house. You have to deal with the other stuff. And so it usually isn't the best decision. It's usually not the best thing. The trust is usually the best, but the transfer on death deed is better than nothing. Okay. And so it allows you to have smooth transition of ownership without probate, but the same things are true as we just talked about with a joint tenant. There's nothing, like if something happens to Johnny when you die or shortly thereafter, there's no postponing that distribution. It's automatic, right? There's no way to say, well, let's see if we can put that in a trust for him to protect it, right? There's no protection if they're in a bad situation when you die. If they get divorced or anything like that, or if they file bankruptcy, that's a problem. Okay. With a will or a trust, you can typically postpone a distribution or potentially revise the thing after the fact in certain cases. So transfer on death deeds work, but they're not the best. Okay. The next thing you can do, and this is only applicable to married couples in community property states. Washington is one of a handful of community property states where when you pass away, a house or asset with title can be transferred to your spouse immediately upon your death. In Washington, I don't know how it is in other community property states because I'm not licensed in other community property states, but in Washington, you can have something called a community property agreement that's a simple 1 or 2 page document that says, hey, all of our stuff is community property. That means it's all joint property, right? I own everything I have with my spouse. And the community property agreement says, when I die, the title to my house will immediately vest in the surviving spouse. So that means when I die, give my spouse my house or our house, right? And the only thing they have to do is record the community property agreement with the county that the house is in, and it passes, right? The positive about that is it's an immediate transfer. It's very simple. The negative thing about it is it just deals with the house typically. Most banks won't take those. But if it's a joint account with a bank, they're not as worried. An issue potentially with the community property agreement is what happens if your spouse is on Medicaid or in a long-term care situation and you don't want them to get the house. Because if they do, the government that's paying their Medicaid bill for their care is going to come put a lien on it later, right? And it also doesn't help with estate tax planning. If there's a taxable estate, Washington has a very low estate tax threshold. And so if you have a community property agreement as your only estate planning document, it's not going to work, right? It's not advantageous typically for the spouse. So you can do those 3 things that we talked about: joint tenancy with right of survivorship, a transfer on death deed, or a community property agreement, but they're not as effective as a will, and they're definitely not as effective as a trust because the trust avoids probate and dictates where everything goes, whereas a will dictates where everything goes, but it's going through probate. So that's it. Okay, those are the things. What happens to your house? Whether you have a will, you don't have a will, if you have a trust, or other things you can do. So now that brings us to our story time for this episode. So I've got 3 short little anecdotes from clients that I have. Okay. The first 2 actually are intestate. Okay. And so that means there was no will. They're probate cases. There was no will. And mom or dad died and they're siblings, right? And so they had to open probate. In the first story, it's a brother and sister, okay? They had to open probate when their parent died. Well, there's no will. But the intestate statute that runs this thing says give everything to my kids because the parent wasn't married. And so there's two kids and the house gets split 50-50 according to state law, okay? The problem in this situation is one of the siblings has money problems. And these money problems have come, maybe they were happening before, I don't know. But after the mom died, right? And so the problem in that situation is one of the beneficiaries may have to file bankruptcy. And so a bankruptcy process in a estate situation is terrible, right? And because there was no will or trust, there's nothing that can be done to postpone distributions. There's no other assets to distribute that would offset the house. And so we're not really sure what's going to happen with this house. There's a lot of questions in the air because of the way the probate laws work regarding how things get distributed in conjunction with the bankruptcy laws that say, hey, if you get stuff from an estate, you have to give it over to your creditors in most cases. So that's a situation where if there would have been planning, they could have potentially said, well, my son has financial problems, so I'm going to give his share to him in a trust or something like that. That can be done in a will or a trust. But since there wasn't a will or trust, there's a mess. Okay, so that's story number one. Story number two is also an intestate estate. Two brothers. Mom died. One of those kids lives in the property. Okay. And he's not paying rent and he's not keeping it up. And he thinks he wants to stay there, but he doesn't have a job and he can't get a real job. He's never going to get a real job. So the issue is they're in probate, but the executor is unable to deal with the house until that person's out. And so there's an eviction that's probably going to have to happen if this person doesn't get out. There's issues with regard to, well, you're going to have to give this kid who's got major problems money, and he's probably going to blow it all, right? And so the planning opportunity there would have been do a will or a trust, protect the kid that you know has got problems. Mom knew that this kid had problems before she died, and unfortunately didn't do anything about it. And so now the other son is having to deal with it on his own. And it's not great. And that's not great for their family, and it's not great for their relationship. So the third story is somewhat positive. The third story involves a surviving spouse, a wife, whose husband died recently. And they came to see me recently, and they had a will. Dad had a will, and basically said, give everything to my wife. Wife wanted to, who's my client, wanted to update her estate planning now that her husband passed away. I said, well, did you do a probate for your husband when he died? No, we haven't done a probate. He died maybe 6 or 8 months before they came to see me. And I said, well, you've got your wills and stuff. They brought in a single will. They didn't bring anything else in. I'm like, well, typically in Washington, at least, when someone does a will plan, an attorney does a will plan, and they had attorney prepared wills that I didn't prepare. But they had attorney prepared wills, and typically in Washington, when you have attorney prepared wills, they do a community property agreement for married couples. So in this case, I said, well, there's probably, check to see if you have a community property agreement and all that stuff that you got from that first lawyer. It would be with the power of attorney and the will and stuff like that. See if there's another document. It'll be short, 1 or 2 pages. And if you have it, that will avoid probate. And so we talked about, well, if we have to do probate, we'll do a probate for the deceased spouse's estate and clear title and all that stuff. But I said, look for this community property agreement. The good thing about this story is they found the community property agreement. They did have a community property agreement. And so they're able to avoid probate for the deceased spouse. And so that's a win, right? The community property agreement worked. They don't have a massive estate. There's no estate tax issues. So for their situation, they had a will and community property agreement. They're not going to have to do a probate for the first spouse. And we're going to avoid the second probate by doing a trust for the surviving spouse. And so their planning was sufficient. Right? They had a will that distributed everything to the surviving spouse. They had a community property agreement that dealt with the house. And so that's a positive, right? That's a situation where the community property agreement worked. And we're going to avoid probate the second time through a trust. Okay? Because the surviving spouse is going to do a trust, give things to her kids through the trust agreement. So yeah, so that's a positive, right? That shows that does work. All we're going to have to do is record that thing and it's clear. Right. So that's it. That brings us to our In the News segment, Something Good. This is more of a Something Good segment this week. And I like to do these. I'll give you a little. I've said it before. I like to do these because it's nice to end with a positive note. Okay. And so that's why I'm doing them. I hope that they're entertaining or interesting or thoughtful. You'll have to let me know in the comments section. If you do make comments in these things, let me know if you like these something good or in the news segments. So this one's about a group in Texas. Families in a tiny Texas town have adopted 77 hard-to-adopt kids inspired by their Baptist church leaders. On the 4th of July, over 2,000 theaters across America ran the film adaptation of the incredible true story of a small town in Texas that adopted 77 of the most at-risk kids from the regional foster system. The movie, called Sound of Hope, the story of Possum Trot, that's got to be a small town, recounts how the voice of God led a pastor and his wife to adopt 2 children and then convince the congregation in the town to follow their lead. It wasn't a large community, but nevertheless, 77 kids found families within 23 households of Possum Trot, Texas. I won't try to do the accent. And this was a big story. Oprah, Today Show, Good Morning America all jumped on this story. But it was years later when a Hollywood director, Josh Weigel, and his producer wife, Rebecca, approached Bishop W.C. Martin and his wife, Donna Martin, whose faith and determination led them to the most mistreated children finding loving families, and took the story to the silver screen. When the church actually does what we're called to do, it's beautiful, Mrs. Weigel said in a behind-the-scenes promotional video. Mrs. Weigel brought the whole production team down to Possum Trot to meet and interview the families and children at the center of the drama before initiating a screenplay rewrite to better share the community's story. The foster system is, as Ms. Weigel explains, ground zero for most childhood trauma in America. It's ground zero for child trafficking and the primary driver of both the prison population and homelessness. And think about how many children are in the system. I believe if every church were focused on 2 or 3 children, they would fix the system just like that, said Bishop Martin. And this film did well. Opened July 4th. It scored various positive reviews, 7 out of 10 on Rotten Tomatoes, A+ from CineScore. It grossed $9.5 million on a budget of $8.1 million in the first 2 weeks of release. So they made money. That's positive. I don't know what happens with the money. They're probably still going to make some more money. To be honest with you, I'm glad I did it, the bishop says, when asked what it took for him to decide, even with little money and 2 children already, to adopt 2 more. God knows what we don't know, and sometimes we just have to be obedient. It's a great story. And that sort of hits home for me. So that's a great story. You know, it's a positive story that shows what a small group of people can do for a group of kids that are at risk, right? And basically it's a group of people that saved 77 kids' lives, potentially, or at least gave them the hand up that they wouldn't have otherwise had if they stayed in the foster system. And this story is personal to me because one of my brothers has also adopted multiple kids from at-risk situations and help them have better lives here than they would have had otherwise. And so I've got all these little nieces and nephews that are from all over the world, basically, that have thrived here more than they would have in their home country of Haiti. And so it's a good story. So hopefully it's something that you like. But that's it. That's it for today's episode. Thanks for listening to today's episode of Legacy Talk. If you like this episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.